Thank you, Nicole, and welcome everybody. Thank you for the ICAR team for facilitating this breakout session. I'm happy you joined us today. My name is Virginia, and I'm happy to welcome you and briefly introduce to you the Mind to Get project as setting for this session. Afterwards, I will turn the floor to Lydia from SOMO and Julia from Connectors, who can also briefly introduce themselves. So, hold on. In a consortium of 11 organizations, we set out with the Mind the Gap project about 2.5 years ago. And we initiated this project to go beyond the case-by-case analysis of corporate human rights abuses. Instead, we set out to analyze the governance gaps that enable companies to get away with such abuses. And in the process, we came to develop the analytical framework we've just published in July. And this research on which Lydia and Julia will further elaborate on has been a great resource for us, explaining the many harmful corporate strategies companies use to get away with human rights abuses, and really look into the strategies that lead to avoidance for this responsibility. So we couldn't have done this alone as SOMO. We had help from our consortium partners in the DRC, in the OPT, Brazil, Indonesia, Mexico, China, and India, and the European Coalition for Corporate Justice. And of course, also many of our allies in civil society have been of great help testing the framework together with us. So in this session, we briefly wanted to show again what the Mind to Gap framework is, so everybody is aware if you're not already. Lydia, that will be done by Lydia. Our colleague Julia will be presenting a case study on Brumadinho, showing an example how harmful corporate strategies play out in practice. And we really would like to exchange with you on the development of counter strategies to neutralize or counter the harmful corporate strategy we've identified in the framework. So let me give the floor then to Lydia for the, to run us through the research. If you have questions for clarifications, there's of course time to ask them to Lydia directly. Questions more for discussion, please keep them until the end, where we have reserved some time to have hopefully a good group exchange. Lydia, the floor is yours.
Thanks, Virginia. And also thanks, ICAR, for inviting us to further share this framework with you all, and hopefully get a lot of good exchanges going on the next stages in the development of the framework. So my name is Lydia. I'm a researcher with SOMO, and yeah, I'm one of the people involved in this project. So both at the global level, establishing this framework, and more at the local level, working with partners in Palestine on specific cases of corporate impunity and countering those corporate strategies we see there. So as Virginia said, I'll give a quick explanation as to what we mean when we say the Mind the Gap framework, and then Julia will take over with an example from Brazil. So the focus of this project, as Virginia explained, is to not only go case by case in terms of holding companies to account or understanding how they are involved and what they are involved in, and how to hold them to account, but really to dig deeper and see what are the patterns, why do these situations keep recurring, and what are the trends we see, and how can we possibly address that systemic layer that is present everywhere. So we identified, based on scoping exercises, case studies, lots of consultations with groups around the world, including in Geneva, where some of you might have been present. We came to a listing of 5 main corporate strategies that companies use to ultimately avoid responsibility for those abuses, for human rights abuses. And I have to be clear, because normally when we use the word strategies, we would think that the intent of the action is, for example, in this case, the intent would be to avoid liability or to avoid accountability. However, when studying these cases, of course, there are all sorts of indicators of what the company aims for, which is get away, sometimes literally get away with murder. But that's not often it's difficult to prove that that was in fact the intent. But we do see that it is almost without exception the result of the strategy. So therefore we say that we observe corporate strategies that ultimately lead to the company avoiding responsibility or not being held liable. In many of the cases that might also be intended, but it's something that we cannot prove, and therefore, yeah, it is something we have to keep in mind. Strategies are resulting in the company not being held to account. We've identified, if you can go to the next slide, Virginia. So I'll start with the first one. As you see here, we have 5 main strategies identified: constructing deniability, avoiding liability through judicial strategies, distracting and obfuscating stakeholders, undermining defenders and communities, and the last one, utilizing state power. And for each of those, I'll explain what the general category is, and how we've subdivided that into more specific strategies by the company. Next slide, please. So the first one is the construction of deniability. And it comes down to companies with the complexity of corporate structures, with the complexity of global supply chains and value chains. The company being able to say the responsibility doesn't lie with them, but with another actor, whether or not the other actor is identified. So they do that through complex supply chains, which they say they don't have a good overview over, or they don't know who suppliers or, for example, suppliers or sources are. Another one is outsourcing high liability activities. So we see that when it comes to labor issues or anything to do with waste dumping, you see everything that is potentially a liability in the jurisdiction that the company is operating in. They try to shift that to other entities. The same with outsourcing of labor relations, where there are jurisdictions with lower standards or a smaller likelihood of being held to account. We see that the labor relations there are put there more often, and different types of labor relations are put there. Finally, irresponsibly disengagement to avoid responsibility. Yeah, it might have occurred in some of the work that you all do when you criticize a company for its involvement in abuses or pollution. If the company is finding it difficult to address the issue and doesn't quite know how to resolve it while remaining involved, they then sometimes just cut and run, and obviously that can result in a lot more harmful impacts, such as loss of access to livelihood, further pollution, and in fact the abuses that occurred not being resolved at all. And the last point on the constructing deniability, companies benefit from the current status quo, where they don't actually have to disclose a whole lot of information. It's very difficult, and in most cases almost impossible to get a company to disclose information, and that's what they, of course, can benefit from. So there's no smoking gun in many cases. Then next slide, please. The second main strategy we found has to do with legal proceedings, legal mechanisms that are used by companies. So one is what we see in the context of ongoing litigation, where, for example, a community or NGO has taken a company to court. They have the company oftentimes has a lot of resources to spend, large, either they have their own legal counsel or they hire an expensive law firm that can find every little maze in the law, every little letter of the law to try and obstruct the case or to stretch out the case for as long as possible, so that the resources of the complainants ultimately run dry. That will be the result in the end. The second subcategory we see here is engaging in jurisdiction shopping. It's very similar to outsourcing the risky activities, but in this case, it's focused on really on the legal regime. So they try to make sure that the legal regime is in favor of the activities, or they put the activities in jurisdiction where the standards are the lowest. Yeah, I guess you are all familiar with that. I'll speed up a bit. Then taking states to international arbitration is another strategy we see when a state might be undertaking to better prevent or protect human rights abuses, making sure that there's a safe environment in their under jurisdiction. When laws are then going to be put into place, for example, a company can take that state to court and say, here you are taking measures that will ultimately harm our profit making, and here's the calculation, that's the claim that we are going to go after you for. Then the fourth out of 5 judicial strategies is shielding the parent company from liability. This is in most jurisdictions still possible, unfortunately, where it's not a given that you can sue a parent company for actions or omissions by its subsidiary. So again, that's something that parent companies do always try to use. The last one is settling cases. This strategy is, it leads to some people getting some form of compensation, but it is not oftentimes not nearly enough to make up for the harms, the damages, and the losses that people suffered. So the settling of cases doesn't set any precedent in law, and it often also doesn't really equate to justice or remediation. So therefore, it's again a way that companies ultimately avoid full accountability for their actions. And then we go to the third strategy. Main strategy is distracting and obfuscating stakeholders. This is a very diverse one, where we see it goes from influencing public opinion, but also academia, and I'll quickly run through these. So one is the symbolic engagement of communities. So rather than really addressing issues that are raised by people affected by activities, there is for example, a dialogue or a roundtable or a workshop, and a kind of tick of the box exercises to try and prevent any real talk on accountability and actually addressing the issues at hand. The second one is the dissemination of distorted information. That can happen through a variety of channels. It can be the company's own channels. It can be through media. Unfortunately, in some countries, we can even see companies almost directly dictating what ends up in a newspaper. And that's obviously the narrative that the company wants to put forward, rather than what is happening on the ground objectively. Then we see another way companies can distract or obfuscate stakeholders is the engaging in fraudulent activities. One example is you might be aware of the trade that we see in the goods coming from settlements, Israeli settlements in the occupied Palestinian territory. There, the labels just end up being what it doesn't say originating from an Israeli settlement. It would say, for example, made in Israel, which is something completely different under law. But therefore, these products supposedly end up in foreign markets legally, although the products were sourced illegally and aren't in fact from Israel. But then, yeah, through this fraud, these products can still be traded internationally and stay undetected. Then we see a manipulation of scientific research. Again, this is a whole other ball game. It's where companies have the ability to get articles or get information published that is not in line with what is actually objectively proven or what has consensus among scientists. So one example, which you can also find on the website, is to do with climate research. Companies can there really push what they see is the reality of things. Lastly, the last two, one is promoting suboptimal standards. I guess that speaks for itself. Trying to push certification or standard making that is not really up to scratch when we look at the UN Guiding Principles or international human rights law. Finally, the diverting of complaints through grievance mechanisms. So we have, there is of course the obligation for companies to have a complaints mechanism, but it doesn't mean that all types of complaints can be dealt with by such a mechanism. There are sometimes the grievances or the violations are too grave to be dealt with by such a mechanism. And also there's a certain standard by which the mechanism should operate. And if we see that grave cases are pushed through that mechanism or complaints are pushed through the mechanism without actually leading to any accountability, then we see that as another way of getting rid of actual attempts for remedy. I think I have to, for just giving me a nod, I think I have to go faster through the last two strategies. One is the second last one is the undermining of defenders and communities. Unfortunately, as I guess you're all aware, in recent years we see an increase in attack on human rights defenders as a way to silence their criticism and their efforts to tackle corporate impunity. That's a very obvious one, which happens globally. Another one is the filing of lawsuits to intimidate critics. So that's really the criminalization using the legal proceedings in the country. Then we have the filing of lawsuits is one that will be slap suits. So using existing law, not really aimed at addressing a problem that exists under that law, but rather draining resources from the people that are sued. The criminalization of human rights defenders is another one where they seek to, not only smear the name of groups, but also get them involved in really lengthy processes and kind of undermine their legitimacy in society at large. Then we have the dividing of communities, where just an example, we see a company moving in with a big operation, then part of the community could potentially benefit from that, getting jobs, while the other would only see a loss of livelihood, loss of land, and further conflict. And those two parts of the communities would then typically be played out against each other. That's just one typical example. And the last one is the undermining of unionization. Again, undermining workers' rights to assembly, workers' rights to organize and to freely form and join a union. That is really a core way to make sure that any other labor rights are more difficult to protect. The last one is the utilization of state power. This can happen in any context, but we really see this more often in terms of the effectiveness of ultimately avoiding liability. We see that in states where either the state has a lot to lose if a company were to pull out or not get its way, or in a state where there's an alliant interest between an oppressive regime and a corporation in any case. So the first one is the exploitation of preferential treatment by states. This can happen through regulations, but also having an exclusive economic zone in which a company gets a lot of privilege to operate. Then we see avoiding of regulations through corporate lobbying. Again, I guess that speaks for itself. And the aligning with suppressive state institutions, be it the military, be it police forces, and even the judicial regime. And finally, the engaging of state security forces. So when a company doesn't, for example, want to send in its own private security, or doesn't want to be seen as the actor that has used violence against the community, then they do in some cases call on the security forces of a state to do the dirty work for them, so the company can get away with being the orchestrator of the violence. I'll leave it at that, and I will just maybe give one chance now for questions for clarification before Julia speaks about the case in Brazil. And there's questions, there's room for more questions and discussion later in this session. So if you can't think of anything now, but you remember a question later, that's fine too. And otherwise I'll mute and let Julia take the floor.
Thank you, Lydia. Julia, may I invite you to give us an example how harmful corporate strategies play out in practice in Brazil? And you've prepared a case study that's you can also everybody can find on mindthegap.ngo, and it's part of the evidence base that we've assembled to demonstrate that the analytical framework that we present is in fact really happening and really really exists.
Thank you, Virginia. Thank you. Should I go ahead? Yeah.
Yes, please.
So sorry, my connection is a bit unstable. So I'm using the cell phone because I think it's more reliable. So sorry for that. So first of all, I wanted to thank both ICAR and SOMO for this invitation. It's really an honor to be here, and I think this is an awesome and very important project. So I'm very happy to be representing Connectors as a partner in this Mind the Gap project. So I'm talking today about the case of Brumadinho Dam disaster as a telling example of how a company, in the case, the mining company Vale, has been distracting and obfuscating stakeholders to avoid being accountable. So just to give you a bit of the scenario, I think everybody in this group knows that this is such a famous, unfortunately, and horrible case. So the Brumadinho Dam disaster happened now over a year and a half ago, and it killed over 270 people. 11 people are still missing. 12 million cubic meters of tailing dams were spilled, contaminated water supplies, and seriously damaged the environment. And what is really shocking is that this happened 4 years after the Rio Doce Dam disaster. So the dam of the Rio Doce belonged to Vale also, but in a joint venture together with BHP. So the dam belonged to Samarco. So what happened? So this case is an example of how companies, so here we're talking about Vale and also Tuvisud, but many of you probably know that this is happening for other companies in other cases around the world, how they use strategies to avoid being held accountable. And so in this case, Vale and Tuvisud have abused human rights standards and also legislation. So just to give you a bit of a context, so please, can you change the slide, Virginia? So to give you a bit of context about Brazil, right? So Brumadinho is an example of the predatory mining model in Brazil. So as I mentioned, there's another case and there are other cases. So it's not new. And unfortunately, I think it will happen again anytime soon. Unfortunately, to date, no person or company has been held accountable for the collapse of both dams. I'm talking today about Brumadinho, but in neither cases there were people really held accountable for the disasters. And Vale, Tuvisud, and several of their employees are currently being prosecuted both in Brazil and Germany, but no results yet. And let's see what happens. And I don't. It's hard to say, but it's hard to say that. But I don't think Brazil has learned much from these two horrible disasters. Especially now, it's going to be 5 years of the Rio Dos disaster, and very little change has been done. And more than that, we can see, if you can go to the next slide, please, Virginia, we can see there is a context in which both the legislation and regulatory bodies have been weakened. So the context that enabled Brumadinho and Rio Dos dam disasters to happen not only has not changed, it has got worse. So with the Bolsonaro government. Today, we're not talking about affected communities, how this affects. So we're talking about the way companies behave, but I think it's really important to think on the impacts of communities. So the impacts not felt the same way. So my society, unfortunately, is really racist. So the combination of the structural racism, gender, and class discrimination does put these communities at extreme vulnerability, and including the asymmetry of power against both the private and the state. Another important information is that upstream dam, which is the case for these two dams that I just mentioned, they make people still even more vulnerable to failure. They are already banned in other countries but in Brazil, they've been widely used because it's much cheaper than other alternatives. Currently, we have, this information is from January this year, over 9,900 structures considered high associated potential damage out of around 5,000. So that's a lot. So let's talk about the case. So please, can you move to the next slide, Virginia? So if we follow the burst of the dam in Brumadinho, Brazilian prosecutors, they did collect evidence that the dam's owner, Vale, sought certification for the dam using the services of Tuvisud, a German company. And they sought the certification while knowing there were severe risks, safety risks. The Vale declared that the dam's safety factor was in accordance with worldwide best practices, and the regular inspections had reported that the dam was meeting all necessary safety standards. But according to investigations, apparently there were problems linked to liquefaction, and they knew it at the Bureau de Projetos e Consultoria, which is a Brazilian subsidiary of the German certification company Tuvisud. But even knowing there were these problems, they issued the certification. The Bureau identified problems with the dam's drainage already in March 2018, but they continued and issued the certification in the following months. The Bureau also issued a certification for the dam that was tied to a few recommendations. We must admit there were recommendations, and these recommendations were provided and with a report. And a few issues were raised in these recommendations. For instance, refraining from using heavy equipment at the dump. But as we all know, in the mining sector, this is very unlikely to happen in situation of the mining region. So in the Brumadinho case, at the time of the burst, 427 mining company employees were working at the site, 400. So they were clearly not following this recommendation. Another recommendation was to avoid blastings in the area. So there were blastings in the area. Another important thing is that the norm to declare the dump as safe was set to a lower standard than usual and common for these types of dump safety assessments. It is still unclear what led the Tuvisud subsidiary to take this action. And some experts say, they point to the fact that the Vale company had dismissed 2 companies that had previously refused to issue certifications due to safety concerns. But also underlined that the contract with the certifier was worth approximately 4 million euros, which is a good contract, I guess. These experts also pointed out that the situation that companies such as Vale, they pay for the service of certification bodies, but this situation inevitably leads to a conflict of interests. So as we can see in the case. So there is a strong evidence from Brazilian prosecutors that suggests that Vale was aware of the risks, was aware of the instabilities linked to the B1 dome as early as 2003. And in the study, we don't talk about that, but we had the opportunity to talk. I had the opportunity to talk also to groups that monitor the companies, and they reported this before in several meetings internationally. But internal documents from the company dating from October 2018 reportedly classified the dam as twice as likely to fail than the maximum tolerated risk level under internal guidelines. So these all, show us that errors from previous incidents, such as the Rio Doce disaster, they seem to have repeated in Brumadinho. We see common mistakes. There is a pattern, and this pattern is recognized by the prosecutors. And the prosecutors actually claim that they have robust proof that the Vale former CEO, Flavio Schwartzman, knew there were unacceptable security conditions in several of the company's dams, including Brumadinho. Both companies, Vale and Tuvisud, saw an early version of this study, and they responded to Mind the Gap project. And Vale has rejected responsibility for the dam's failure, and they pointed to the reliance on the certification issued by the Tuvisud Bureau. And they insisted that it was impossible to predict this dam's failure, that the failure was sudden and abrupt, and that the dam safety had been verified by independent experts, and that the technical causes of the dam failure are still not conclusively settled. And Tuvisud pointed out that under Brazilian liability law, the responsibility for safety remains with the dam owner, so that is Vale. And it also highlighted the conditions tied to their certification and the existence of witness statements that have reported breaching one of the conditions. So they both, in the end, mentioned that the dam break has not, the cause for the dam break has not yet been concluded. We must acknowledge that they apologized and they regretted for the victims and families, and Vale also referred to a very big reparation program. But we must notice that in fact this reparation program has received a lot of criticism from several stakeholders. So I guess I'm running out of time, right, Virginia? I should, yeah, right. Should I leave a bit? Just a final comment is just for you to know that Brazilian prosecutors have announced that they have, in January this year, filed charges against 11 of Vale's employees, including the CEO, Fábio Schwartzman, and also 5 of the certifiers employees. These charges included both homicide and environmental damage. And they have been charged with environmental crimes in connection with the Brumadinho case too. But they also, Vale strongly rejects the suggestion of a criminal intent in their dealings with the safety of the dam, and the criminal proceedings are at the early stages, and there are no convictions so far, as I have mentioned in the beginning of my presentation. So this is it for the time being, but we can talk more if you have questions. Thank you, Virginia. It's on you now.
Thank you, Julia. If there are any questions, please raise your hand and I can give you the floor. Otherwise, would like to give the floor back to Lydia for introducing how we intend to follow up on this research. So the examples in the research, like the one Julia just explained about TÜV Süd and Brumadinho, they are core to our research, and we hope to expand the evidence base furthermore. And we have an option on our website that enables you to add more examples. Lydia, can you take the floor?
Bless you. Yes, I'll continue from here. Bless you. Yeah, thanks, Julia, for really taking us along the history of the Brumadinho dam, but also, I guess, really highlighting for everyone how a company can get away with this by shifting the different pieces of responsibility to other actors, or at least trying to. I guess there's still a chance that there will be a form of justice, whether in Brazil or in Germany. Yeah, where do we go from here? So we've identified all these strategies that I mentioned earlier, and we have also started, as you can see on our website, we've started to list what we see as successful counter strategies. So really ways to get to the core of the company's approach and try to find the tools and the mechanisms that work to disarm it, really, and to ultimately achieve accountability, prevention, etc. So what we've done is we are, of course, not going to reinvent the wheel. So we're really engaging through all our networks to get inputs on this, to get inputs on lessons learned, on what has worked well, and why those tools have worked well. And we also intend to share those through the Mind the Gap website. So if you go to mindthegap.ngo, you will see there the ones that we've already pointed to as promising or already having been successful in countering corporate strategies. We are going to develop resources as well over the next 1.5 year, resources that can be used and adapted by yourselves and by the communities and groups that you work with to break the status quo in the cases that you work on. And so I guess we want to really get your thoughts and get the conversation, the discussion here in this room going on 2 main questions. One is, when you think about cases that you've been working on or that your organization has been working on, where communities have actually seen positive improvements resulting from your hard work and the groups that you work with. So what do you consider are the lessons learned for what can be effective counter strategies, or when certain strategies can be effective and how? So any lessons learned, any insights that you would like to share, that would be very welcome now during the session, but also anytime after. You can contact us because these experiences and lessons are really worth sharing on the Mind the Gap website. And the second question is, what do you think is missing in the kind of the knowledge landscape on counter strategies? So we have time and resources available in our consortium to research this further, to dig into why some counter strategies are effective, how they can be most effective. So if you have a particular research question there, then that's very welcome too, where you think there's a knowledge gap that this Mind the Gap project can address. So those are the two main questions we have now for the discussion. After the discussion, we will go to a poll for what you think can be useful components in the counter strategy toolkit. But that's something for after the discussion. And I apologize for the background noise. I'll mute now. Yeah, I would say the floor is open for your inputs, questions, and comments.
So either in the chat box or by, I think you can unmute yourself. We really welcome your brain power in this. We really hope the toolkit can be a resource that's shared for, that's shared and used and complemented by all of civil society. Definitely, it's not our intention to replicate or duplicate or neglect any of the resources already out there. But we really hope to also make a new contribution to what is already out there. So ideas on what is missing, what is the unique contribution that the Mind the Gap project could deliver to resources out there is very much welcome. So one of the things we are exploring is how to categorize the resources, how to make them available, how to show to other civil society organizations what is available and what they can do to counter harmful corporate strategies without actually giving all this information to all the corporates themselves. And maybe it's also useful to see the poll that we've prepared. Do you think would be most useful to include in the Mind the Gap toolkit, and to what resources would be useful to support CSOs, NGOs in developing and strengthening their counter strategies? And these are just some of the ideas that we have, guidance to really identify the harmful corporate strategies as we set out in the framework, develop case studies or lessons learned from other cases, really be a pool or a database of contacts for experts or support organizations, more on corporate research, samples and technique samples, and templates for advocacy or for campaigning, or be more specific, research for human rights defenders, how to use non-judicial complaint mechanisms. These are just a few of the ideas we have. If you have others, please write in the chat what those tools could be. And this would be useful information for us going forward with the project. As Lydia said, definitely not the last opportunity we will facilitate to give input, because it really needs to be something that's useful. And we have our partners from the from the different focus countries in the DRC and Brazil, OPT, Indonesia, India, China, Mexico, who are thinking along with us. But the more input we get from our CSO colleagues around the world, the more targeted and useful we can make this exercise. So if I see answers coming in. If I end the poll, I unfortunately cannot allow any more of you to give in your votes. So I'll read out what I see, and then I'll launch it before I end it, and I'll share it with you. Information on potential judicial avenues is of course highly resourced for human rights defenders. I see samples and template materials for advocacy is something that several of you favor, as well as corporate research methods. Let me share the results with you. So that's really, thank you, that's useful for us to see and know going forward. Because it's really valuable to see what type of direction we should think. And yeah, if I may still invite you to reflect on the questions Julia asks, then I see several comments coming in the chat box, and that's really helpful for us as well. Lydia, there is one question addressed to you, so maybe you can take this one while others may have time to type up some of their questions.
Yeah, I'll read out the question. Wissam has asked, how do you compare challenges in gaps with regards to conflict zones and international humanitarian law versus other situations? Well, I think what we see, again, speaking from the Mind the Gap framework, I mean, the suppressive state that you can align with as a company in the context of conflict and or occupation is really specific. I mean, if, for example, in a non-conflict country, you might have, in the most extreme case, you might have a state of emergency when other laws are shoved aside. And of course, this is used in dictatorships and other places a lot. But what you see in situations of context, that's the norm. And that's the, between brackets, the normal. So military law applies, human rights protections are often really nowhere to be seen. And it's, as we say in Dutch, the butcher judging its own meat. So if you would ever want to have if you would want to have companies or military actors be held to account, you're really asking them to investigate themselves, because there's not really a court available to people living under occupation, oftentimes, or not. It's not effectively available, and a military will be investigating itself with obvious outcomes. So I think the avenues for remedy and for justice are even less than in non-conflict settings. Although many scholars and also states would agree that international human rights law applies in contexts of conflict and occupation just as much as anywhere else, the reality on the ground is often a lot different. So I think, yeah, what I can say in summary is that the strategies that companies can resort to are more extreme and have more extreme outcomes than what you would see elsewhere. So when we look at the governance gaps in the context of Palestine, and we look at counter strategies, we are really looking beyond the sphere of occupation and the occupation authorities, because yeah, I think it has to be worth the effort, and we have to be rational in our choices. So it wouldn't make sense to go through the occupation authorities, because that has been tried for decades and that hasn't led to anything. So that's how I would compare. I'll mute again because there is a lot of background noise here. But I did see Kristen Dobson's input that it would be helpful to see a full list in one place of avenues for accountability that groups have used. So again, please do feel free either on this session or following this session to share what your experiences have been. I think all exercises that people have tried are useful to learn from. So please, if not today, then after today, feel free to share, because we will collate everything and try to really extract lessons from the collective efforts within this community. I'll mute now, I'm sorry.
Thank you. And thank you also, Paul Roeland, for suggesting to approaching the investor sphere. Definitely, we're going to look at the different stakeholder groups we can sort of mobilize in an effort to counter those harmful corporate strategies. So these few reflections were very valuable to us. We would have loved to go deeper into with you into the content, and we have a more proper brainstorm. Obviously, that works better in a face-to-face setting, but we've gained some inspiration to take our work further. And as said, it's not the last opportunity we'll provide to give input, and you'll be hearing more from us and inviting you to either suggest resources for us to include or pick your brain and how to make the toolkit more valuable. And we also invite any academics to approach us if you have interest in the in any of the aspects of our analytical framework and like to take that further. And hopefully in a year or so we have launched the toolkit and it's all available for everybody to use. Yeah, so we really need you for now. We really thank you for joining us and joining the ICAR online annual meeting. And yeah, I think I have all the inspiration now. We would furthermore really hope that this analytical framework can be, taken forward, and not just in the counter strategy phase that we are currently in, as well as going to focus on advocacy avenues to close governance gaps that enable companies to get away with corporate human rights abuses, but also to get the framework more more and more accepted. That's not just a brainwave of this project, but that it's something that civil society as a whole shares. So we'll be also going to be seeking for endorsements for the framework in support of the approach, and hopefully we get to see some of your names as endorsers. Thank you, Julia and Lydia, and I think I'll give the floor back to Nicole for some last words.